Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in our case number IC19 0012. Counsel, each side has 20 minutes for your argument. Appellant may reserve some time for rebuttal. I would ask that you track that yourself. Our proceedings today are being audio and video recorded and live streamed. Please introduce yourself and your clients at the start. We have read the briefs, discussed the case at conference, and we're familiar with the arguments. Please keep that in mind. And with that, counsel, you may proceed.
Steve Baker for the City of Surprise and the Arizona Municipal Risk Retention Pool, and I'll reserve approximately 5 minutes in rebuttal. The decision issued by the judge in this matter should be set aside because the judge erroneously found that the applicant suffered a compensable injury in 2017 simply because he suffered a blow to the head without more.
Are you challenging the 2005 injury?
Yes, because it is I didn't mean to cut you off.
Not, you didn't.
Because it is intertwined with the 2017 injury. The judge found.
Isn't your position that it's not intertwined?
No, it is intertwined.
Okay.
And so if you set aside the 2017 claim under the case of Employers Mutual versus Industrial Commission, you have to set aside the entire case for hearings de novo.
Well, if I have an injury that's not medically stationary from 2005, and then I stub my toe getting into the elevator, the fact that my stubbed toe isn't compensable doesn't say anything about my horrible injury in 2005.
Except for, in this case, what the judge found is that the applicant required continuing benefits for both injuries and didn't segregate them out. So we don't know. What she found is that the applicant requires continuing care for the 2005 and 2017 injury, erroneously assuming that the 2017 injury was compensable.
Let's assume then that the ALJ made an error in finding the 2017 injury compensable. If the 2017 injury had never happened, the 2005 injury would be unaffected and would still be compensable.
Correct. The issue.
So how does the fact that he got hit on the head by a golf bag wind up in a windfall for?
It's not a windfall. It's unfortunately the way the courts have interpreted what you have to do with a court industrial commission case. In the industrial commission setting, if you set aside an award, you can't set aside part and affirm a part. You have to set aside the entire award. And that's stated in the Employers Mutual case. So unfortunately, because the cases were consolidated, if you set aside the 2017 injury, I believe you have to refer the entire case back to hearing for hearings de novo.
Okay, so it's the workers' comp equivalent of reversal.
Correct. So in this case,
That's a common law rule, or is that
statute. I believe it's a statutory interpretation.
a statute? So
Yes.
even if we are to affirm the 2005, which would provide, let's say, the identical universe of benefits, not a single one more or less, and we were going to, let's say, deny, I guess, on the 2017, that doesn't matter. We're obligated under statute to send the whole thing back.
I believe in this case you are, because the judge did not segregate out what treatment was being recommended on a continuing benefits case matter for either injury. She simply lumped them both together, erroneously concluding that the 2017 injury was compensable.
But your argument is there was nothing for the 2017 injury.
Correct.
So what treatment are you arguing was lumped in to the 2005 that wouldn't be compensable? I'm just trying to understand.
Sure.
Let's say this, you're wrong, the statutory argument you're raising is incorrect.
Okay.
You're saying 2017 bump on the head, nothing more.
Correct.
Stub toe explanation. What do you think she added that wasn't covered as part of the 2005 injury? Because you're saying if it existed, then it had to be the 2005.
And that's one of the problems with the case, is that we don't know what she was adding because she doesn't discuss, and none of the experts said that he needed treatment above and beyond what he was already getting for the 2017 claim.
So there's a possibility that there could be a difference in benefits or treatment based upon the two separate instances. It's
Correct.
not a complete overlap.
Correct, because in order to prove compensability under Yates, so under Yates, it's not enough just to show that I punctured my finger at work. I've got to show that there's some accompanying loss in the form of...
No, but I'm saying
Okay.
that I'm looking on the back end, okay? We have a pool of benefits that's at issue, okay? And if it's the identical universe of benefits from A to Z on both the 2005 and the 2017, and the ALJ says they both are good, why do we remand for the court to say, okay, we're going to take away the 2017, but on the back end, we're talking about the identical universe of benefits?
Because we don't know that that's what the judge meant to do when she issued her award. We don't know what benefits she was awarding for the 2017 claim. Now, it's my position that there were no additional benefits for the 2017 claim, but we don't know that from her decision. We don't know
Is there
what the
any-
segregation was.
Is there any evidence that any of the benefits were in addition? Because I'm going to Dr. Flitman's testimony. Even your argument is Dr. Flitman can't even say there were additional things needed because of this. So there's no evidence that she would have had to say, I'm going to give you something additional in the 2017.
And I
In your
understand
argument.
that, but I believe under the obligations you have at the Court of Appeals level, you can only either affirm the award or
Then what's-
reverse the award
Well,
in
let
total.
me ask you, then,
Okay.
are you conceding that there was and is something compensable about the 2005 injury? You're just saying that it's muddled by the 2017 injury?
The 2005 injury was found compensable. It was an accepted claim. So the issue in the 2005 case was what continuing benefits is he entitled to, and she didn't segregate out.
But are you challenging that the notion that there might be some continuing benefits stemming from the 2005 injury?
If you find that he was not stationary, yes. If you agree with the judge that the applicant was not stationary, then there would be medical treatment that he would
But
be
your
entitled-
client found he was stationary.
Correct. But that was the issue in regard to the 2005 injury. In regard to 2005 injury, the issue was, does he need more treatment for the industrial injury on an active care
Okay,
basis?
so you're not contesting the ALJ's finding that your client was wrong
No, I am contesting.
on the stationary.
Correct. But we all accept the fact that the claim had been accepted.
So if the result in this case were the judge erred on the 2017 injury, but was correct in determining that there is a need for continuing benefits arising from the 2005 injury, the judge now needs to make sure that those benefits are correctly calculated. That result would be acceptable to you?
If we have a new hearing and get to present the case de novo. If
Well,
that,
de novo on the scope
Both
of
claims.
benefits?
on
or-
both claims. As to one, in regard to 2005, is he entitled to continuing benefits in the form of ongoing active medical care?
Okay, let me ask you to do this.
Okay.
Pretend 2017 never happened.
Gotcha.
What's wrong with, and leaving aside the commingling of benefits?
Okay.
What's wrong with the judge's determination of the 2005?
On the 2000, that was extensively briefed. The problem is on that decision is that there was conflicting, not just conflicting, but the doctor's own records didn't support that there was an industrial injury. I mean, there was no mention of this particular incident.
But
His
that's
own-
compensability, not whether it's an ongoing problem.
No, but-
You seem to be going back to trying to challenge the compensability there.
No. What we were challenging is the foundation of the doctor to render opinions. His opinions were based upon statements the applicant made to the IME physicians, which were not supported by the doctor's own
So
records.
let me ask you this.
Sure.
If there is evidence in the record, let's say, to support the ALJ's finding that there was an ongoing need, Dr. Flipman testified to that, she found Dr. Flipman more credible. Do we affirm that and then we remand? Because we don't reweigh her decision in that regard.
I believe in this case you would have to, yes.
And so your de novo hearing,
Would be the whole thing.
that we're affirming that she was
Oh.
correct.
If you, I don't think you can, but if you did that and it was sent back to the Industrial Commission, then you are correct. We would not relitigate the 2005.
Okay. Let me ask you, what was the case again that you said?
Employers Mutual. Let me find it for you. Employers Mutual, 115, Arizona, 439, Court App, 1977.
439?
439.
Thank you.
So in Yates, the fact that I punctured my finger alone wasn't sufficient to establish that I suffered a compensable claim. There has to be an additional loss. In this case, the judge accepted the testimony of Dr. Crandall that there was a contusion, but Dr. Crandall specifically said that it didn't require any medical treatment, and there was no testimony that there was any kind of permanent or temporary disability arising from the 2017 injury. I don't believe the judge recognized that in order for there to be a compensable injury, there has to be more than just an incident. There also has to be some type of loss. It doesn't appear that she recognized that. But let's just, and so for the sake of argument, let's just assume that Dr. Flipman's testimony is correct. It is not equivocal. Let's just assume that Dr. Flipman testified that the 2017 injury required medical treatment above and beyond what was already required for the 2005 injury. Let's just assume he testified to that fact. As you know, under the Supreme Court's decision recently in Aguirre, judges are required to identify conflicting evidence on important issues, explicitly state their resolution of the conflicts, find the ultimate facts, and set forth the application of the law to those facts. And in Aguirre, the court held that if the judge does not do so, the matter is remanded for further hearings to weigh the evidence. Here, I don't believe the judge recognized that there was a conflict between Dr. Flipman and Dr. Crandall as to whether or not there was in fact a compensable 2017 injury. In her decision, she just assumed that because there was a blow to the head that everyone agreed occurred, there was a compensable injury. And that's just simply not the law. She didn't recognize that, I don't think, and didn't make any material findings saying, I accept, I see there's a conflict in the evidence, here's the conflict, I resolved the conflict in favor of Dr. X, because she resolved the conflict in favor of Dr. Crandall, who said there was no compensable 2017 injury. So for that reason alone, you would have to remand the case back to the Industrial Commission because there's insufficient findings of fact, because I don't think the judge recognized there was a conflict in the medical evidence. Let's just assume, so if I'm correct, then you would have to remand the case back to the judge for further findings. But it's our position that Dr. Flipman's testimony on the 2017 injury was equivocal, subject to 2 or more interpretations. He avoided committing himself to what he was testifying to, and when you look at his testimony in the hearing transcript at page 19, dated 8/29/2018, he was given a history as to how the injured worker was injured by Mr. Whitley. He was told he suffered a blow to the head. Then he was told, I want you to assume that this aggravated his already existing condition. And even with that, being told he suffered a blow to the head and that it had aggravated his underlying condition per his testimony, Dr. Flipman could only say that he didn't have sufficient information to tell you that the second incident was an aggravating factor. He was already receiving the same treatment before the injury. I don't really know that I can prove it.
Well, and let me just ask, because her findings were this. No evidence was submitted to contradict this eyewitness testimony, and the applicant's own account of how this eyewitness, how the injury occurred, Dr. Crandall concluded that applicant sustained a contusion to the back of his head. Then her next sentence is, there is little, if any, conflict on the evidence regarding the compensability of applicant's claim. So she says there is little. That could acknowledge Dr. Crandall says no, nothing, and that Dr. Flitman says, I think there is. And doesn't that at least address it? Do we assume that she just ignored it when we have that, at least second sentence? If it wasn't there, I might be more inclined, but how do you deal with the second sentence?
There's little, if any, conflict. There's a direct conflict. I mean, it's not just a little conflict. It was the major conflict on the 2017 injury.
And that's your characterization, but can't she characterize it as just a little conflict?
I don't think so. I am hard pressed.
But we don't weigh.
Yeah, I am hard pressed to read that as a recognition, as required in Aguirre, of a material discrepancy.
Okay.
I'm hard pressed to see that is a recognition. Yes, there is in fact a conflict as to whether or not this was or was not a compensable claim. So there's no more questioning of Dr. Flitman on direct. We moved across. We then come back to redirect. Mr. Whitley takes a second run at the question. And this time, Dr. Flitman says, can't be 100% certain. It's likely, given the presence of neck pain and the pain regarding his right arm, these are symptoms that make me think about neck injury and possible radicular injury affecting the neck. So it would certainly be suggestive that there were more things happening that would be aggravating type of injury, would be an aggravating type of injury. So we have in the one sentence, likely, suggestive, possible. And if you parse it out, it comes out to likely, suggestive, possible. So he doesn't really commit himself and say, yes, to a reasonable degree of probability or something to that effect. This gentleman did suffer a blow to the head that required additional medical treatment he was not already getting, or increased his disability, preventing him from working. There was nothing even close to that from Dr. Flitman. So, in my opinion, the decision has to be set aside because the judge simply didn't recognize that there was even a conflict in the medical evidence on that 2017 claim.
There wasn't nearly enough from your perspective. You can't say she didn't recognize that, given that second sentence. I think, would you concede that?
No, I wouldn't. And the reason is that in the decision, she indicates, if I remember it correctly, she indicates he suffered a blow to the head.
Right.
There's little, if any, conflict in the evidence. As I read the decision, there's little, if any, conflict in the evidence on that issue that he suffered a blow to the head. Not that there's a conflict in the evidence as to whether or not he required additional medical care above and beyond what he was already getting.
And I have it, because I want to just really parse that language with you just a moment. The sentence is, there's little, if any, conflict in the evidence regarding the compensability of applicant's claim. It's same paragraph, but it's still a new thought. She says clearly contusion and little conflict on the compensability.
But I think it's modified by Dr. Crandall concluded that applicant sustained a contusion to the back of his head. And I think what she's saying, there's little, if any, conflict on that issue. But I think what she's saying is she's assuming that a contusion to the back of the head is sufficient for a compensable. That's how I read it.
I understand.
Thank you very much. I've got a little over 2 minutes.
Thank you, counsel.
Thank you. May it please the court, I'm Jan Weinstein. I represent Joseph Spector, the respondent in this matter. Let me put aside my notes of what I was going to address to the court and start with Mr. Baker's argument about whether or not this case can be remanded in part and affirmed in part. And the statutory provision that governs that issue is ARS 23-951D.
Say it again.
I'm sorry, it's ARS 23-951D, which authorizes this court to affirm or set aside an award. However, there is case law, and the operative case is Professional Furniture Service versus Industrial Commission, which you can find at 133 Arizona 206. It was decided by this court in 1982. Professional furniture was a case similar to this one. And let me back up for a moment. I know that Judge Gass is relatively new to this court, and I don't know his familiarity with industrial commission cases, but industrial commission hearings address different issues in a claim sequentially. So the first issue that may be disputed by the parties could be compensability. They could agree on other issues, and later there could be disputes about whether there's a loss of earning capacity and whether what the average monthly wage is for an applicant. And so there is typically one issue in a hearing. Sometimes in a single claim, two different legal issues can be assessed. For example, what is the applicant's average monthly wage, and is there a loss of earning capacity? So if those two issues are brought together, you might have one award that addresses two distinct legal issues. In those cases, because it is one claim, and the Court of Appeals may say, well, the ALJ got the average monthly wage correct, but did not correctly decide disability benefits, I need to set aside the entire award and remand it. In fact, the Court of Appeals has found that, I'm sorry, Judge.
I'm actually looking at professional furniture service now, and it seems to hinge, I mean, it does hold what you represent, but it seems to hinge on the fact that in the award position, I'm quoting now, in the award position of the disposition, separate and distinct awards are made as to each claim. That didn't happen here, right?
That did not happen here, but all the other circumstances in professional furniture are present here, and the most important one is we have two completely distinct claims, and I believe one of you raised that issue before Mr. Baker. Aren't these two claims distinct? And in fact, they are distinct.
Well, but let's say for a moment that, and I tend to agree with you that they're distinct, although that may not be what you want to argue. Let's say that the 2017 injury doesn't hold up. How are we, but the 2005 does. How are we to evaluate the award when there is no separate award?
If you look at the award itself, there may not be any separate award, but the findings are made relating to each award distinctly. So to the extent that it's remanded in the 2017 claim, the findings that were made are meaningless in that claim, and that claim will move forward with a de novo hearing on compensability.
Which one?
The 2017 claim. You're saying assuming that one gets remanded in 2005?
Oh, I'm not assuming it gets remanded. I'm assuming that it gets completely thrown out. Let's assume that we just don't find evidence to support compensability on the 2017 claim, but find that the ALJ properly, within the range of her discretion, weighed the evidence and found what she found on 2005. We still don't know what the result should be because she didn't segregate them out. And that seems to be a big distinction between this case and professional furniture.
Well, I don't know if your concern is segregating out the benefits or segregating, I mean, the 2005 claim, she made it clear that, and I can tell you which paragraph. And I apologize for taking so long. She did set out exactly paragraph 15. With regard to applicant's condition for September 4, 2005, and it just states Flitman's opinion with respect to 2005, that he still needs treatment for cervical dystonia. Okay, so it specifies exactly that is the treatment for 2005. Let me address your question.
What does she say about the treatment for 2017?
Well, and that's the next issue I want to get to. Compensability, it just means, is there a compensable claim? Was there an accident? Did it produce an injury? And did that injury require some benefit to be paid, either disability benefits because you missed work, or some kind of medical care, even minor medical care? The ALJ on the second claim decided only compensability, A separate injury is the scope and breadth of the injury. So in other words, I fell and skinned my knee here arguing today, and I have a compensable claim, but now I realize I have a bruise on the knee, I tore a ligament, I also banged my head. It's compensable because we know I skinned my knee and I had to go to the hospital for the skinned knee. The question is, are all these other things that occurred within the compensable claim? The ALJ did not undertake that, nor was she asked to. Her issue was, is this claim compensable or not? Now, lots of evidence was presented by both parties about whether or not the back was part of the claim, the tremors were part of the claim.
When you say the claim, which one are you talking about?
2017.
Okay.
2015 was accepted as a compensable claim,
Right.
and the reason we went through all these other issues was really the defendants were trying to say, hey, all of his medical problems that he's getting treatment for, we don't think it's within the scope of the claim. We think Dr. Flintman established that it was within the scope of the claim, that it was therefore, again, related to the industrial injury. But compensability...
So is it your contention that the 2017 claim is irrelevant here?
It's not irrelevant, but it is distinct from 2015.
Well, but what did he get from it?
It might not, that has not yet been determined because the scope of his injuries have not been determined.
Okay, you'll have to pardon me.
For purposes of 2017, the judge did not decide exactly which of his medical conditions were causally related to what happened in 2017. She basically said...
Did she plan to do so? Because we're here at the Court of Appeals. I'm assuming that she thought she was done.
She was done in terms of determining whether there's a compensable claim or not. The next stage is saying which of his medical conditions were exacerbated or worsened or created by the 2017 injury.
I've been here a while and not seen a case with this sort of interlocutory review. Am I missing a jurisdictional provision that allows us to review piecemeal the various stages of these claims?
And that is the nature of workers' compensation, is that there are separate issues and claims. And very often when the issue of is someone medically stationary comes up, with that is, well, it depends what you deem to be included as a causally related medical condition or injury. And here, the ALJ simply said, you have a compensable claim, now you figure out, and if you can't agree, we'll have another hearing, what the scope of the injuries are and whether those injuries are medically stationary.
So is this appeal premature?
Of the 2000, I
No,
think...
should we be here today? Or should this appeal have come after the next stage in the evaluation of the 2017 claim?
I think under the Workers' Compensation Act, a party has a right, once an award is issued, to appeal that award, to bring a statutory special action challenging that award. It might very well be premature, but these defendants are saying there is no compensable claim for 2017, and of course the applicant is saying, look, there are several ways to find it compensable.
But let's say we agree with the appellant. Let's say we say, yeah, there's no evidence for a compensable 2017 claim. What's the result? There was all this testimony and findings on the 2005 claim. If we disturb the 2017 decision and not the 2005 decision, where does that leave?
I think that the court is permitted to do that under the professional furniture case, say the 2005 claim is affirmed and the 2007 claim, the award to the extent it affects the 2017 is vacated because there was no evidence of compensability. Where does that leave the applicant? The applicant is left with that paragraph 12, what Dr. Flintman just said, and that was adopted by the ALJ, that these injuries from 2005, they were related to the 2005 accident, and you still need medical treatment for all of the injuries listed, except for, I think, the eye twitches were determined to be medically stationary and just required some supportive care. So the applicant will go forward on that basis, getting treatment under the 2005 claim. And the
Would
2000...
the applicant feel that there was anything left to do in front of the ALJ if that were the result of this appeal?
In other words, would the applicant want to have a new hearing to
Yeah.
determine compensability on the 2017 claim?
No. Assuming the 2017 claim is just dead and gone,
Okay.
does the applicant feel that there's anything more to do in front of the ALJ, or does the applicant simply want to continue receiving treatment?
With respect to the 2005 claim, assuming that this court will issue a bifurcated ruling and affirm 2005 under professional furniture, bless you,
Thank you.
I believe that the applicant will continue to get treatment in accordance with the 2005 claim and hopefully become medically stationary in due course.
Then until some medical event occurs that makes him medically stationary, there's no more legal work to do on the 2005 claim, even if the 2017 claim evaporates.
There would be the normal stages in a workers' comp claim, but with
nothing
respect to
immediate.
these issues here,
Nothing immediate. There may be something in the future, but nothing immediate.
I can't, Your Honor, I can't tell you that the average monthly wage has been determined or his disability, but again, that's normal stages. With respect to the issues that have been addressed here, no, these issues, there'd be nothing further to do.
So, Counsel, let me ask you a quick question. I'm looking at Kiewitkowski, a 2012 decision talking about professional furniture. And it says that when a consolidated decision separately disposes of severable claims, this court may severally dispose of them upon review. Now, the question is whether or not there are severable claims, okay? What does that mean? Is that 2 claims for benefits? Is that a single award, 2 awards? What does that mean? Severable claims, which would apparently allow us to do what you're talking about.
Severable claims would mean, as in this case, 2 distinct claims where the issues, to resolve the issues in one does not require the presence of the other. In other words, if these 2 cases had been assigned to 2 different ALJs, which they were initially, and Mr. Baker asked that they be consolidated, these judges, it wouldn't be necessary for the other case to be present for one case to be decided. When you have 2 distinct claims that would not be capable of looked at severally is if you have, it's a later issue in cases where you may say, okay, here is an applicant who is injured at this employer and is getting an award and benefits, and injured in this employer and getting a different award and benefits, and there has to be apportionment between and among the awards so that there's not duplicate benefit. That's 2 separate claims where the very issue that is being decided necessitates joining both cases together.
Let me ask you this, in this case, was there any independent additional injury argued as a result of the 2017 case, or was it that at most the 2017 injury caused an exacerbation of the 2005 condition?
And please don't shoot the messenger when I answer your question
No,
in this
I
way.
don't shoot anybody.
The judge did not take on that issue. The judge was just saying, is there a compensable claim or not? In other words, was there an injury as the result of a workplace accident that caused this applicant to either require medical care or miss work? And her findings do support that, and maybe that's why in her conclusory paragraph she just said based on everything in the record, because we know that Mr. Spector did miss work. His symptoms worsened severely after the second accident, despite his pain and symptoms prior to the second accident.
Then how is it severable? I mean, if the point of severability is we want a complete narrative that begins with chapter 1 and ends with the end, apparently here we have a 2005 injury and we have a 2017 exacerbating, I think is the word we were using. Isn't that part of the narrative, and wouldn't that defeat your severability claim?
That has not been decided. I mean, the evidence was put in by both sides about what exactly happened to him physically after this accident, and the question was not answered by the judge. The judge only determined, is there a compensable claim? Did he require some additional medical treatment, or did he lose money, lose earnings as a result of this accident? And the answer is yes. There's plenty of evidence in here to show he had to go on opioid pain medication, which of course precludes a firefighter from going to work. He had physical therapy as a result of this second accident. He did get a contusion on his head, for which he stayed at home and rest. So, but it hasn't been decided whether and to what extent the injuries that he complained of were the result of the second accident or simply a continuation of the first
Well, I think
accident.
it wasn't fair to say that it was decided that the 2017 injury aggravated the 2005 injury. Isn't that the basic theory here?
I don't know that the judge actually made that finding. Now,
don't
this,
either.
in terms, but that's just the point. The only issue before this court is there evidence that there is a compensable claim? And we say, yes, there is evidence there's a compensable claim, because Dr. Flitman, and I do want to address something that Mr. Baker said, Dr. Flitman's testimony was not equivocal. He basically said, look, I can't be 100% certain. Well, he's not required to be 100% certain. If he can say, he said that the way the accident happened is consistent with a worsening of the injury. His testimony was very clear. I cannot be 100% certain. However, it's likely, given the presence of instant neck pain and pain regarding the right arm, these are symptoms that make me think about neck injury and possible radicular injury affecting the neck. So it would be suggested that there was more things happening that would be an aggravating type of injury. Dr. Flitman said prior to that,
the last sentence that you said was it would be consistent with aggravated.
an aggravating type of injury. So he says it's likely and consistent with an aggravating type of injury. But the ALJ did not specifically say, as a result of this second accident, here are the compensable injuries. She just said it's compensable for one of many reasons, and you people will later sort out which injuries were aggravated or caused by 2000.
We have to
Judge.
sort that out for severability concerns. If we have this sort of binary, different conclusion on 2005 and 2017.
I don't believe the court needs to sort that out, because if you will indulge me, if 2005 is fine, if it's an appropriate award, if it's well supported by the record, 2017, the question is then, what new injuries or what aggravation to your old injuries exist? There is absolutely no reason why on remand that issue can't be addressed and should be addressed separately by a new judge. And that happens all the time at the Industrial Commission. One judge will decide compensability, and then the next judge will say, okay, let's see what of all your medical ailments are either idiopathic or caused by the injury in addition to the bump on the head that you got. And that's exactly what I'm proposing, is that you send it back saying 2005 claim is fine, continue. 2017, there is enough to show that there was some medical treatment, maybe it was a very short-lived exacerbation, and any injury resulting from 2017 is now stable and gone, but that can be decided independently
Well, the
by a new
stability argument
judge.
comes later. Compensability starts, and then when he's stable, he either accepts their decision that it's stable, or he can challenge it, correct? In other words, the first issue is compensability, whatever treatment follows, but at some point they argue, somebody says it's medically stable.
Correct. And Judge, typically that's the way it goes. First compensability, then. But in this case, the way the judge did it, and it is done this way at the Industrial Commission, not infrequently, the first judge, where there's a lot of issues and a lot of evidence, and there's, just says it's compensable. You sort out which injuries are within the scope of the compensable claim.
Because we are at the stage where only compensability is going to determine the future work that have to be done to determine benefits for the 2017 injury, If we disagree with you and find that the evidence was not sufficient to support compensability, you're just done at that point, right? Because in your view, the existing award only gives benefits for the 2005.
The existing, if you find that the 2017 claim is not compensable, only the 2005 award would go forward to provide benefits.
Right, and the current award that is on appeal now really only awards benefits for the 2005 injury.
Because it did
They
not,
haven't been calculated for 2017.
because they didn't even address which injuries are compensable under 2017. Before I go on, I know I'm over time, I do want to address for the court, I would ask that you read carefully, and it's on pages 36 and 37 of the answering brief, exactly Dr. Flitman's testimony, because under the case law cited in the brief, all he has to do is testify that it is probable and that the mechanism of injury is consistent with the damage. You don't have to have a medical opinion that is absolutely certain, and Dr. Flitman is by no means an IME doctor. He's a treating doctor, and he's like, I can't be 100% certain, but his testimony is enough under the case law to support the conclusion that there was an exacerbation.
Well, it's not just that he can't be 100% certain. He says, I don't have sufficient information to be able to tell you that the second incident was an aggravating factor.
And then he goes on to say, I can see how it could be given the mechanism of injury. He says it's possible that
But
he
that's
could.
not proof.
Well,
That's less than a preponderance.
he says, but let me go on, because if you take all of his testimony, it's possible that he could now have resulting more neck dystonia. And then in the further examination, it was pointed out to him that Mr. Spector testified, and the judge adopted Mr. Spector's testimony, that immediately after he did have more neck dystonia, and in fact, he had to stop working as a firefighter engineer because he could no longer turn his head to make lane changes. That is in the record, and the ALJ accepted that testimony. And based on that testimony, combined with Dr. Flitman's testimony, causation is established that there was an aggravation of his cervical dystonia. I thank you for indulging me in going over the time limit. Thank you.
Thank you, Ms. Weinstein. Mr. Baker.
Thank you very much. Briefly, the example given by applicant's counsel that I fall and skin my knee and that's a compensable injury, that's just not correct. There has to be more. There has to be an incident plus a loss, and the courts have defined loss as medical testimony establishing to a reasonable degree of probability there's a need for medical care or there's a disability of some kind. And that just isn't here to show that there was a compensable injury.
What about the evidence concerning at least the brief time after the 2017 event that it couldn't perform functions essentially?
No, doctor, but what we're talking about when we talk about disability is medical evidence indicating that there's a medical reason why he can't do that work. In fact, if I fall and I skin my knee and I don't go to work the next day, but no doctor took me off work, no doctor said I had a disability that precludes me from work.
Okay, fair enough. And given the limited time, I just want to ask you if you agree with your colleague that there's no benefits component to the award on appeal now that relates to 2017. So if you prevail on 2017, I'm struggling to find the point of the ruling.
Okay, and I was going to, thank you very much. So on page 10 of the judge's decision, in concluding that the applicant needs additional care for the 2005 injury, what she says is this: Dr. Flitman concluded that applicant's condition and the need for continuing care and treatment is related to a combination of both the 2005 and the February 14, 2017 industrial injuries. So what happened is, I think the judge made a mistake in not keeping the claims severable. She did not, so we don't know.
Well, okay, you might be right, but then let me ask, is there a portion of the existing award that you think is not attributable to the 2005 injury? And that
Yes.
you conflated the two wrongly, and there's a piece of this award we should take out because that's 2017 stuff.
Unfortunately, I don't think we can segregate, but I'm going to tell you, what my position is when you read her decision, you can't tell whether or not she's saying that the need for continuing care is, that there is a need for continuing care in and of itself as opposed to in combination with the February injury. She did not keep them severed. She muddled them together, for lack of a better legal term.
Conflated.
Conflated would be the better nickel term.
Thank you, Mr. Baker.
Thank you, Judge.
And thank you both for your arguments. We will take it under advisement and be adjourned.